This micro talk is part of a mini-series on the FINRA Notice on private placements. We encourage you to review the entire mini-series available on our free writings and perspectives blog. Thank you. The earlier guidance under Notice 10-22 stated that a member or associated person recommending a private placement should at a minimum conduct a reasonable investigation regarding the issuer and its management, the business prospects of the issuer, the assets held by or to be acquired by the issuer, the claims being made, and the intended use of proceeds of the offering. Since the issuance of that guidance in 2010, through its exams and disciplinary actions, FINRA has observed other areas in which members' investigations into private placements could be strengthened. As laid out in Notice 23-08, as part of a reasonable investigation of a private placement, members should address, where relevant, the following. First, regulatory and litigation history. This includes the criminal, disciplinary, regulatory, and litigation history of the issuer, its management, and any affiliate that may be materially involved in the issuer's business. This is necessary to ensure the issuer's compliance with the bad actor provisions under SEC Rule 506. Second, new material developments. This includes events that are or reasonably should be known to the member during an offering. Examples of this include any ongoing legal proceedings or regulatory inquiries involving the issuer. Third, transactions or payments between an issuer and the issuer's affiliates involving offering proceeds. To the extent these exist, it is important to know the terms of the transaction and whether any arrangement presents a material conflict of interest for the issuer, and if so, as the sufficiency of the disclosure of that conflict. And then finally, the representations of past performance of the issuer, its sponsor, or its manager. This is helpful to identify any representations that may be misleading or exclusively selected based on positive results or cherry picking. Importantly, a reasonable investigation must independently verify an issuer's material representations and claims, particularly when the member or the associated persons are affiliated with the issuer or when red flags are present. Among other things, a member's analysis of the offering should not rely solely upon representations made by the issuer and its affiliates. Information provided by third parties, whether it be attorneys or due diligence experts, should be reviewed with reasonable care, taking into account the independence, incentives, and qualifications of the third parties. A member may demonstrate that it has conducted a reasonable independent investigation by documenting the inquiries, the research, and the analysis that the member conducted, by obtaining additional information from an issuer to perform an independent analysis of their representations. For example, if a PPM contains a representation regarding certain contracts or permits that are material, the member should consider reviewing copies of such contracts or permits. Members also should analyze third-party due diligence reports. And again, keep in mind, when a member encounters red flags through its own review, the member must investigate and address those issues prior to recommending the offering. Another point worth mentioning here is that although in practice, often the member firms are the ones who gather the information and conduct an investigation prior to approving an offering, associated persons themselves have an independent obligation to satisfy Reg BI or Rule 2111 when they make a recommendation. I encourage you to review the notice in its entirety. I also encourage you to visit Mayor Brown's free writings and perspectives blog for additional information on this topic and other regulatory developments. Thank you for your time.